I kind of want to get from the room your perspective and see what you think the word leave means to you. So, assuming the clicker's going to work. There we go. So what does leave mean? You have a lot of different choices here. Gary, are they able to choose multiple? So you can pick as many that you think apply. All right, and I think as these come in, this is pretty fair representation, I think, of what leave might mean in the workplace. We're talking about when somebody is taking time off, generally speaking in workers' comp, you're talking about taking time off to convalesce. But the bottom one, to get out, and it's not just a shameless way for me to insert a video from the movie Get Out, although maybe it is. But the phone call that oftentimes we get from our clients is, we have somebody who's been off on leave for a while, and we don't have a job we can put them back into, and this person may be a risk to himself and to others, and how do we get them out of there legally? Well, Greg and Carl just talked to you about retaliatory discharge, and so it gets complicated when you want to start to move somebody out. And so we'll talk about leave in both those contexts. And now I'll put this shameless video in.
Get out.
Sorry, man.
Okay.
Get out!
Now, I used that not because it was the only clip that I had, but because the kind of anxiety in the phone conference that we will have when somebody wants that employee out, and we're trying to find alternatives legally. I almost feel like, even though I can't see the person on the other end of the phone, that they might just have a nosebleed, that they're just so anxious about it. I said, this is actually sort of fitting. But this is a workers' compensation seminar. So many of you have done this with us before when we've talked about the intersection of the ADA, workers' compensation, and FMLA. And it's probably been from a different perspective, probably more employment-oriented. This presentation is not that. There are many aspects to the Americans with Disability Act because they don't all involve employment, okay? You can be on family medical leave, and it has nothing to do with workplace injury. I'm unconcerned with that because this is a workers' compensation seminar. So what we're concerned about here are the instances in which these laws intersect when you have a workers' compensation claim. That's the only thing that would be relevant to somebody who is a workers' compensation practitioner. So understanding how the laws intersect in workers' compensation also requires an understanding of what these laws are really about, okay? Now, everybody here knows something about workers' comp. Workers' comp has been, in Ohio, has been the law since 1913. So we're over 100 years with workers' compensation. The purpose is simple. Workers' compensation is designed to pay benefits and compensation to people who get hurt at work. It was part of the grand bargain so that employers could avoid having to go defend injuries at work in court all the time, because that becomes very expensive. And so workers' compensation has a finite purpose, okay? It does have some discrimination aspects to it because, as Greg and Carl just told you, there is a retaliatory discharge provision to the statute, but for the most part, the statute deals with paying benefits to people who can't come back to the job that they were doing before they got hurt. The ADA is totally different. Okay, and this law has not been around that long. It's only been around since 1990, which to me seems like yesterday. And compared to how long the workers' compensation law has been around, it is just yesterday. But this is a disability statute, okay? It's designed to give people with disabilities a fair shake, which is why there's going to be a workplace aspect to it, but the law is much broader than that because we're talking about disabilities and discrimination generally as it applies to people with disabilities. The Family Medical Leave Act is also a fairly recent law. It's been around since 1993. Its purpose is primarily to balance, the workplace pressures with family life when you have somebody that's got a serious health condition. And so it's a leave statute, okay? Allows people to take time off because they need to be with a family member or because they themselves have a particular health condition, they need time off, but it's a leave statute. So here you've got three different kinds of statutes. One that's designed to compensate, leave is a part of that. You have another one that is designed to prevent discrimination. Leave could be a part of that, and we'll discuss that later too. And then you have a leave statute in the FMLA. So the common thread among all these laws, or at least the way I see it, when we're talking about how are they going to intersect for your purposes managing workers' compensation, is in the medical condition, okay? Because if you don't have a medical condition that's taking somebody off from work, then you don't have a situation where the workers' comp law is going to intersect with FMLA and also ADA. Yeah, you might have an intersection between FMLA and ADA, but workers' comp would be out of the equation. You have to have a medical condition to take somebody off from work. And it's the medical condition. So you heard presentations earlier, I think it was Rob and April talked to you about idiopathic, okay? Workers' compensation law is designed to provide benefits for people who are injured. It's any injury that occurs in the course of and arising out of employment. This also includes psychiatric conditions. I didn't include that in the definition because I figure this is a fairly sophisticated group. So people know that psychiatric conditions can also be covered under the workers' compensation law. It also covers occupational diseases. So diseases that are contracted in employment are also covered by the workers' compensation law. The ADA is concerned with a disability. And a disability can also arise from a situation in which somebody is injured. So disabilities, under the ADA's definition, would be a physical or mental condition that substantially limits a major life activity. It's a much different kind of definition, but I'm going to show you that for your purposes as workers' comp practitioners, it's probably going to involve your workers' comp claims when you have a claim that is not simply a scratch of the elbow. And so under this definition, you have a couple more components, whether they have a record of an impairment or they're regarded as having an impairment. The main thing for you to remember, though, is that we're talking about something that's serious enough to substantially limit a major life activity. So the next question is, what's a major life activity? Well, the answer to that question is anything, really. I mean, this is not an exhaustive list here, but these are the kinds of things that are major life activities. And on this list, which one do you think is most significant when we're talking about workers' comp? Working. If somebody has a workers' compensation injury or an occupational disease, okay, and they can't come back to work for 4 or 5 months, let's say it's a herniated disc, you might just now have ADA requirements as well, depending on the circumstances, depending on what stage you are in managing that particular claim. The FMLA has a different definition. It's looking at serious health conditions. If you have a hospital stay of 3 or more days, I think it is, a period of incapacity due to a chronic serious condition. There's more to the definition than this. These are the ones that are relevant to what our discussion is. So what are we talking about? We're talking about a serious condition. Again, not one that's going to resolve in a couple of days, not one that you would consider med-only. So your med-only claims are not part of the discussion here. We're talking about a real claim. Workers' comp claim is only relevant to you, for the most part, once you start paying some compensation on it. I mean, we're going to pay attention to the ones that are med-only also. They can develop into claims for which there's compensation. But once somebody's out of work for 7 days or more, and you start paying them workers' compensation, it's that kind of an injury, it's serious enough, you're looking at the FMLA too, probably. So, first question, this one should be pretty easy. Claimant lifts boxes at work, herniates his disc at L5S1. He requires emergency surgery and cannot return to work for 6 months. Is this injury covered by, well, and 100%? Oh, no. All right, here we have, okay, now we're getting the, it can depend. That's true. That's true. I'm going to. We'll get to that in a second. All things get covered eventually in the presentation. All right, and I'm going to say at this point, I'm not going to ding anybody. You're all right. I mean, it really is. It's all of the above, but it depends. It really depends on the circumstances, and that's what we're going to go over. But the point of this and the point of the poll was that when you have an injury of this sort, that you can't just think of it myopically and just think, all right, I'm only concerned with the workers' compensation law. Even if it's not you personally that deals with application of FMLA and ADA, you need to be aware that there could be other laws that are implicated when you have an injury or an occupational disease that has some lasting period to it. The other laws may be invoked. So this is not really a trick question, but chances are all of them are involved. And so now we're going to answer this young woman's question because she's yes, we're all young in God's eyes. So this little chart kind of tells you some of the distinctions between coverage under the law. Okay, workers' compensation, it applies if you have a place of employment. Okay, one or more employees. I can safely say that everybody in this room is in a place of employment that would be covered by workers' compensation. Okay, the key for leave purposes in workers' compensation is called temporary total disability compensation. Okay, there's also permanent and total disability compensation, but at that point, you're not really on leave. You're not coming back. That's compensation of last resort. Okay, but for purposes of convalescing, taking time off, temporary total disability compensation, the standard is inability to return to the former position of employment. That entitles you to benefits until something else happens. FMLA has other criteria. You have to have 50 or more employees within a 75-mile radius. You have to have been employed by the employer for 12 months or more. Okay, so that answers your question. If they've only been employed with you for 6 months, the FMLA doesn't apply. The FMLA looks back to whether or not they have worked 1,250 hours within the last, I guess it would be from, how can I say this? Because I want to say the last year, but it's the last 12 months. Okay, everyone calculates their FMLA year differently, and there are a lot of different ways to do it. But as a general rule, you say 1 year back, they have to have worked 1,250 hours. These two laws are for all practical purposes, your leave laws, okay? That's what separates them from the ADA. The ADA is not a leave law, but it does have a leave element to it. The ADA, we're talking 15 or more employees, except there is an Ohio corollary, okay? There's an Ohio statute that is substantially the same as the ADA, and under the Ohio law, which is going to follow the same kind of case law as the federal law, it's only 4 employees or more, so you can get captured there. And again, leave under the ADA context falls into the whole business of reasonable accommodation. So you have to consider all 3 of these laws, even though technically they come into play at different points. So the next question is, and this one everyone should get right, which of these 3 laws permits an employee to go on leave? So if we were playing Who Wants to Be a Millionaire, we could rely on the audience here, okay? Because the majority of people have said all of the above. And that's true. It's true. Clearly under workers' comp, clearly under the FMLA, and also under the ADA, it can be considered a reasonable accommodation to a disability. So, if you have somebody who is on workers' compensation leave, this is like a practice tip because chances are you're going to also want to put them on FMLA, assuming that it applies, assuming that they're covered. So you run them concurrently. You can't just do it, though, in a vacuum. You cannot just simply say, man, this person's taken off, they're going on TT for a while. All right, let me check my little boxes here, and I'm going to start putting them on FMLA. You can't do that without telling them, okay? You have to designate it as FMLA. But once you do, then assuming it's a straight leave, everything, they're covered under the requisites of the statute, then it's going to run its course for 12 weeks of leave. I put together a chart, though, to show you where these things tend to intersect with one another. I put a check next to injury in all categories. And again, the reason I did that is because I'm not thinking about an injury that has no serious consequences, okay? I'm talking about injuries that are disabling, serious kinds of injuries. If you have, and the way to think about it is not necessarily by the label that you put on the injury, because you could have a lumbar strain that lasts for an extended period of time. It could be a chronic lumbar strain that just continues to flare up and doesn't get better. It could keep somebody out of work for an extended period of time. You could possibly meet the definitions of both the FMLA and the ADA because of the duration that the person is out, okay? If they can't do all the things that were on that list and they can't work, clearly it's a disability. So those are the kinds of injuries we're talking about. We're not talking about paper cuts. We're not talking about something that gets where somebody comes back to work in 14 days. So in serious injuries situations and occupational diseases, you're probably going to invoke all 3 laws at some point, not at the same time. When somebody has been offered light duty, thank you. Everyone knows what light duty is. Everyone probably has a light duty program. And employers like to do it because if they can get the employee back to work without having to disrupt the workplace, they can avoid having to pay workers' compensation benefits, okay? So you look for a job. You say, he's capable of doing this. We have this in our plant or in our place of employment. Person can do it. there's a depends next to FMLA because, the first thought is, well, if somebody's working light duty, then they're not on leave. Well, it depends on the light duty. Because if the light duty has them back and they're there, full time, well, that's one thing. But if they're not working light duty full time, maybe your light duty position has them working 20 hours a week. And the remainder of the time, they're at home. Well, if that's the case, then they're probably eligible for FMLA too, for that period of time, the leave period, that they're not actually at work. The ADA, put a check next to that. You haven't run afoul of the law when somebody's on light duty. You're actually sort of complying with the goals of that law. The problems arise when somebody's not at work under the ADA. And then the question is, are you discriminating against them because of their disability? But if they're on light duty, if they're receiving benefits under the law, whether it's, full temporary total disability compensation, or you have provided a job that they can do that's within their restrictions, and then the ADA has been satisfied. You have not run afoul of the law at that point. When they can't return to work, obviously they're going to receive temporary total disability compensation. More than likely, there's FMLA too, okay? Because they're on leave. The ADA at this point is silent. They're unconcerned. As I just said, the person is receiving benefits. They're not being discriminated against. They're being treated like anybody else that has a work injury. So the ADA is satisfied with your actions. But here's where problems start to rise. Person's been off work, let's say, for a year. Now you've done an MMI determination in the comp system, okay? So under the workers' comp law, once somebody is MMI, you stop paying them the benefits, okay? And once you stop paying them the benefits, chances are you're thinking, all right, either they've got to come back to work or we have to start looking at some other strategies. Whether or not FMLA applies really depends on how long they've been off work, okay? If we're working with my scenario where they've been off 6 months to a year, 12 weeks is 12 weeks. And chances are they will not have worked 1,250 hours in the previous year because they've been off on disability. The ADA now comes into play because the question is, what do you do with them? What do you do with this person now that they're no longer deriving a benefit under the workers' comp law, they're not getting a benefit under the FMLA? Do we need to engage in the interactive process and try to find a way to get this person back to work? Or if there is no job available, can we legally terminate them? And so returning to work under the workers' compensation law, there's no requirement to send somebody back to work. You pay benefits, you pay compensation, you pay benefits. There's no duty to put somebody back to work. Same thing is true with the FMLA. It's a leave statute. It gives you time off. ADA, well, if somebody's at that point, you have to engage in that interactive process to determine what they're capable of. And you could have them go out for an FCE to determine what their work capabilities are. They have to be able to perform the essential functions of the job, okay? And they're only qualified for ADA benefits, okay, or protection, ADA protection, if they are able to do the essential elements of the job with or without a reasonable accommodation, okay? Termination, get out. That is the thing. You have a neutral attendance policy, and you want to terminate them. Years ago, that was a problem in workers' comp because there was a case called Coolidge that everybody was concerned about. They thought under Coolidge, if I terminate somebody, or before Coolidge, if I terminate somebody under a neutral attendance policy, then I'm liable for some sort of damages. The Coolidge case came out and said that's not the case. If you fire them under a neutral termination policy, there's no problem under the workers' compensation law. FMLA clearly doesn't apply. ADA, even if you have a neutral attendance policy, if you just nilly-willy terminate somebody without going through the interactive process, you say, I've got this policy, it says you can't come back after a year, you're gone. Can't do it. That's illegal. That's illegal. You have to engage in the interactive process to see what they're capable of doing. So, claimant's off for a year, MMI no longer receives TT comp, FMLA is exhausted, company leave policy is exhausted, they want additional leave. Are you required to give them additional leave under any of these laws? They're MMI now. Okay, this is a pretty smart audience. Yes, under the ADA. In the circuit in which we sit, which is the Sixth is determined that 6 months off is a reasonable accommodation for additional leave. If the person says, I think I need a little bit more time to get healthy. I need a little bit more time. A little bit more time, though, is pretty nondescript. There's some other courts of appeals, other circuits, that don't feel the same way as the Sixth. That when someone says, I just need more time, and they can't give you a definite time when they're coming back, and it's indefinite, then that is not a reasonable accommodation according to other courts, because the thought is that you're no longer qualified. If you cannot tell me when you can return to work, either with or without these restrictions or accommodations, then that is not what the law is designed to cover, according to other circuit courts. In the Sixth District, though, they have carved out 6 months. And so that can be a way to comply with or you may be required to provide additional leave to comply with the ADA if someone says, I need an additional time, give me 6 months, and they can get a doctor to put together some documentation to support that. Do I have another survey? I think we covered this one pretty safely, didn't we? Claimant off work for a year under neutral policy, wants to terminate employment. Can you terminate under? I mean, your only concern in workers' comp is retaliatory discharge, like Greg and Carl talked to you about. ADA, you can't terminate them under a neutral policy without engaging in the interactive process. And FMLA doesn't really come into play here. All right, so very rarely are all three of these laws involved at the same time, okay? The thing to be concerned about is the timing. ADA tends to be an end stage. It's like when you're dying of cancer. It's an end stage disease. ADA is at the end. When the person is exhausted their leave, they no longer have leave under your S&A program, they no longer have leave under the workers' comp, they don't have it under the FMLA, they're off work, they still have a very serious health condition. So they're, I know I'm using FMLA terminology, but it's the same concept. They're very hurt. That's when the ADA comes into play. The thing to be concerned with is making sure that all of your departments, as I said, not everybody does FMLA and ADA work. If we're all workers' comp practitioners, sometimes you tend to think of things very narrowly. You wear that workers' comp hat. The point of this presentation, though, is to make you aware that there are circumstances in which the other laws come into play. And hopefully the chart kind of helps you. You could take that back and kind of refer to it. But When you are in that situation, that's when you want to get the other people in your office or in your company involved, or maybe contact your lawyer, someone to advise you on whether or not you potentially have liability or coverage under these laws, depending on the circumstances. Thank you.